make sure we cover. So we're just going to do a quick overview so that everybody's on the same page with what is a trust. It's a private agreement, okay? It's a contract between you, the person who's making the trust, and the person who you designate as the trustee. So while you're alive and well, typically most of our clients are naming themselves as their own trustee initially. And then in the document it's got the order of succession after you. And then the trust also has the instructions about how you want your money, your property used. Okay. Now while you are your own trustee, you get to do whatever you want. You can break all the rules, nobody cares, okay? But once the trustee is not you, those rules are set in stone. They have to be followed. So one of the things we're going to talk about today are the duties of the trustee, and the fact that those duties come under a legal standard called the fiduciary duties. And that means they have to put your interest ahead of their own as they're following the terms of the trust. That's for the attorneys. Okay. I'm going to set up a little bit of a framework so we all have the time periods that the trustee, I know you guys won't be able to see this very well in the back, but that just is what it is. These different time periods in life are different with regard to who's trustee and the rules of operation. That's the day their fiduciary duties start, and the day they become liable. Their job as trustee is really broken down into 3 big phases, okay? And this can span during any of these time periods. If they don't take over until death, or if they start earlier, or if they start voluntarily by you giving up control, it can be broken down into 3 phases. The first one is to protect and collect all the assets. Second one is to pay all claims. And the third one is to make distributions. I haven't mentioned anything about taking care of you, the person. Like taking you to the doctor, making sure you're living in the right place, making sure you're safe, making sure you have the right just things happening in your day-to-day personal life. Because that's not really the trustee's job, okay? That stuff falls onto the shoulders of your healthcare agent. So we're not going to spend a lot of time talking about that. Their job is to arrange all the medical, arrange where you live, make sure you have the entertainment you want, make sure you're doing the family visits that you want, or whatever. Their job is to make sure you're happy, comfortable, safe, healthy. Trustee's job is strictly to manage the trust assets for the benefit of the beneficiaries. While you're alive, you're the beneficiary. After death, it's whoever you've designated. Okay?
Can that be the same person though, the trustee and the health agent?
Yeah, the trustee and the healthcare agent can be the same person. Doesn't have to be, but can. Okay, their first job is to collect and protect the assets. When I asked you guys at the beginning, do you keep your finances in perfect audit-ready format, all that kind of stuff? And, nobody emphatically said, yeah, I do. Nobody does. Your trustee now must, starting on this day, going forward, they must keep those type of records. It has to be perfect. Because there are people your beneficiaries who will someday have the right to audit their activity.
This doesn't have to be terribly complicated. I mean, if you got a checking account, a bank account.
It doesn't have to be terribly complicated. It doesn't have to be. The first thing we do is they will sign a document that says, I accept the duties of trustee, dated December 14, 2017. That date marks day 0. Okay?
Where do they get the document?
We help them with that. We get that form. Yep. Sign that document. They then go with instructions from us to, within about 30 days, to start collecting all of your statements, all of your financial assets, all the records of everything, real estate, businesses, investments, whatever it is, everything. Car insurance, home insurance, health insurance. You have to inventory all that stuff. And then out here somewhere, they'll look back at that date they started, and we will create their first trustee report. That is a beginning balance of all the assets, bank, checking, savings, investments, everything, and an inventory, a general inventory of any house contents, vehicles, value of real estate, just everything has to be on there. They'll create that trust report, they'll have all the backup documentation attached to it, and they stick it in their file. They put it in our file. And then from that day forward, we tell them no cash transactions whatsoever. Only check or debit card or credit card. 0 cash transactions. If it's appropriate for you to have some cash, that's fine. There can be a discretionary cash allowance. But that has to be, it can't be thousands of dollars a month, okay? It's like hundreds, right? The rest needs to be controlled and it needs to be traceable. But it doesn't have to be complicated. As long as they do all their transactions by check, credit card, or debit card, there's an audit trail, right? It's all going to show up. So as part of this first step of creating the trust report for that date, they're also going to notify all the institutions. Okay? Every financial institution that you've done business with that show up on this trust report need to know you're incapacitated or you have voluntarily given up the job. Why do they need to know that?
Because you have the legal authority to do anything on it.
Yeah, a couple of reasons. They need to know that because we don't want an incapacitated person making decisions, right? I mean, as hard as that is to say, we tell clients this all the time. No, you shouldn't have credit card access anymore. You shouldn't have debit card access anymore. That's a hard conversation to have. You guys might only have to do it once or twice in your life. We do it all the time. We don't want that person to have access. Okay, worst case scenario was the husband was incapacitated, and the wife really hadn't been involved in the finances at all. And so when he was declining, got to the point where she needed to take over, she found out that he had over a dozen different charities that were auto charging his credit card every month for donations to some whatever bogus charities. And it's the kind of thing, it's a phone call, hey, there's children dying in Africa, do you want to give $20 a month? Oh yeah, here's my card number. And it was just going. I mean, this was hundreds of dollars a month. So you just have to cut that access off. The second reason is you need your trustee to be able to sign checks and take money out and use and direct the assets. So they need the legal authority to control the trust assets. So they have to notify all the institutions. Okay, and then what will happen is now your bank account, your real estate, your vehicle, everything that has a registered title instead of saying, I'll use myself, so instead of saying Francisco as trustee, it'll switch to my wife, Nicole, as trustee, okay, of the Servant Family Trust. And my name will only show up in the name of the trust. It won't show up in the name of the trustee. So if I were to call the institution after that and say, hey, I want to donate money to blah, 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 they'd look at the account and they wouldn't initiate the transaction. At least they shouldn't, because I'm no longer the account holder.
What if they do? What are the, how do you?
There's ramifications. The trustee will go back to them if they've done this part right. They'll go back to them and say, excuse me, you just stole my money. I'm the one in charge of this. Okay? Now, I mean, if I came back and I said, hey, I'm fine, I'm healthy, I never did that, they're stealing my money, they're going to initiate an investigation. If I can prove, things, then I can take the account back over. But if they just did it willy-nilly, then yeah, they would have to make the trust whole. So that's that first phase. That's how they protect and collect the assets. Now this same thing happens if they start the job after death, okay? If I were just to get into a car accident, my trustee picks up the job here, their first job is to collect and protect the assets, okay? And their date will be the date of death, okay? If they start at that point, their beginning date. Now the second thing that's going to trigger phase 2 is something that they do during this phase. So whenever we have a client become incapacitated and we need to transfer authority down to their successor trustee, and we help with this process, during this time period, can they make any changes to their trust? If you became incapacitated, Jackie, can you make changes to your trust after that?
No.
No? What do you say, Seth?
I don't think so.
You don't think so? Anybody else have a different idea? No.
Well, if one of the two people is incapacitated, that person could, but the other person could.
Actually, no.
No?
It's not that clear.
Oh, okay.
No, it's not that clear. If somebody, in a married situation, there's a joint trust, come on in. Come on in, come on in. If there's a joint trust, it isn't that clear. Okay, there's going to be, are you okay? Then it's not that clear. Sometimes yes, or some parts of the trust can be amended. But for the most part, a general rule is that during this time period, your trust is irrevocable. Okay? So we'll go with the general rule for purposes of this discussion. Now, if they can't amend their trust, how do you think that affects who was named as a beneficiary after death? Think about that, right? I become incapacitated today, and I had some charity designated as a beneficiary after I die, and I can no longer change my trust. It sticks, right?
Yes.
Right? My trustee can't change it. My power of attorney can't change it. I'm saying the general rule. That's important to know because it is irrevocable during this time period. These beneficiaries now have rights.
In the case where you have a husband and wife,
Yeah.
and one becomes incapacitated, does the one that's still managing, that person has control of it?
Yes.
Your co-trustees.
Correct.
Okay. So you're only in trouble if both of you go down at the same time.
Yeah. Well, then your successor trustee
Yeah.
steps in. The married couple's trust. Okay. There's the general rule that I'm going to go with, which I don't remember if it applies specifically to you. The general rule is that the beneficiary after the death of one spouse is the other spouse. And so if that's the case, we're not worried about the other spouse,
Okay.
okay?
So the point is, if, I mean, like, we're pretty fortunate now, we don't have any problems with our family, but if one of them, say, would wind up in drugs or.
You want to do this stuff while there are no problems.
Right,
Yeah.
right.
That's when you do this, right? You buy insurance before the car accident. And that's what this is. This is a little piece of insurance so that if you get down the road and somebody gets upset, you can go, hey, too bad, so sad. You know, that's the trust, those were the wishes, it's done.
It seems like I've heard that some people, maybe it's TV, I don't know, put something in their will or their trust that says if the beneficiaries fight it,
Oh, yeah.
then they don't get anything.
Oh yeah, and you all have that in yours.
Okay.
And we've used it at least 2 times that I can remember off the top of my head.
Okay.
And it's great because we highlight that and we go, yeah, you know, it's usually their lawyer, and we go, hey, look at section 10 whatever.
Okay.
And then you go, okay. Yeah, just send us the information. We're good. So yeah, it's called a no contest clause. Yeah. So that's part of what happens here. Now with that, it starts this 4-month window for anybody to file a claim. I've never had somebody file a challenge during that 4-month window for those 2 reasons. The no contest clause, right? And then the second one is nobody's upset or mad during this time period. It happens after the fact. And then they're like, oh, the ship sailed, crap, you know, they lost it. So it's a great idea to use that to your advantage. Paying claims, this is just all about taking care of the bills, okay? The trustee is responsible for making sure all the bills are paid, medical, everything, you know. It's 100%, while you're alive, 100% of it is to take care of you, period. If they need to hire us to do some legal documents, if they need to hire an accountant or CPA for your benefit, if they need to hire caregivers, I mean, whatever they need to do, they're allowed to do. And in fact, they should do. The other thing that can be a claim during this time period are the trustee fees. Okay? Now, Arizona is really vague on, Arizona law is really vague on what trustee fees or executor fees are supposed to be. We have what we call a reasonable standard, which means whatever you want it to mean. What has been litigated and appealed and decided, and we now have some case law on, which is the only thing we can sort of extrapolate from, is that the courts will approve a hourly based fee system for somebody who's an individual non-licensed trustee. They will approve a hourly, they will approve a percent management fee for corporate trustees like banks and trust departments. A lot of times they'll charge like 0.5%, 1%, 2%, the range is all over the board per year. And they'll do all the tax returns and that kind of stuff as well. But it usually can get very expensive very quickly. And those are the 2 kind of ways to do it. During this time period, if it's during this time period of incapacity, when I sit down with the successor trustee, I always ask them right up front, when we're signing these first documents to collect and protect the assets, say, are you going to charge a fee? Almost everybody, 9 out of 10, is a family member, and they say, no, I'm not going to charge a fee. And I say, that's fine. I don't care if you do or don't, but you're required. I'm telling you, you're required to keep track of your time, period. Because 3 months from now, when you go, holy crap, I just lost, 80 hours of work, and I'm traveling, and I'm blah, 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 I have to charge for my time. We have the documentation to go back and do that, okay? So that does happen. I don't know how often, but maybe 20% of the time. Somebody will retroactively say, no, I'm a few months in, I need to charge for my time. And so we'll help them do that. And the ranges anywhere from $30 to $100 per hour. It depends on the type of task they are doing at the time. So they have to keep a description of what they're doing. And, if it's, sweeping out the house, it's at, $15 an hour. If it's doing the taxes, it's $100 an hour or whatever. So it's just along that spectrum.
And any if they have travel expenses or something, that's
Yep.
just covered.
Anything out of pocket absolutely gets reimbursed out of your trust. Okay, and it's kind of weird sitting as trustee for somebody else. Most family members have never done it. And so they're like, I'm writing a check from the trust, I'm signing it as the trustee to me for reimbursement or for my fees. So a lot of them feels kind of weird, and we have to help them kind of, sort through that. All of the fees, if they do charge, not the reimbursable expenses, but the fees are income to the trustee. Okay, so they have to pay taxes on it and that kind of stuff. They have to declare it as ordinary income, and it has to all get reported like that. So those are the claims. Now we get to distributions in two different ways. During your lifetime, all the distributions are to you. After death, the distributions are to the beneficiaries. They won't get to this, at least we never recommend getting to that, until well after this is all done. Okay, after somebody passes away, I see it happen a lot where like people just start writing checks and making distributions, just like splitting up the assets, and 2 months everything's gone. There are just some big risks of doing that. There's a lot of liability your trustee takes when they make those distributions. If they make the distributions and then another bill pops up, or a tax bill, or the distributions weren't calculated correctly, what do? They go after the beneficiaries, say, give me money back? Legally, they can. Think they're going to get it back? So who's responsible? They've got to pull out of their own pocket, make that stuff right. Okay? We always try to tell beneficiaries after a death, it's going to be at least 6 months before you're going to see a distribution. At least, probably longer. Okay? Because we have to wait at least this 4-month time period. We have to do an accounting, right? We've got to pull the records and make sure the numbers match up for the distributions. Even if it's a seemingly simple distribution plan, something like equally to my 3 kids or whatever, that's fine. We just have to make sure we know what the actual balance is before we split it equally.
So a lot of our assets will be in our IRA, they just go to the beneficiary, they don't go through the trust, right?
Yeah. So if you have IRAs, anything with a beneficiary on it, IRA, if you have life insurance, you might have direct beneficiaries. If the beneficiary of those is your trust, or I should say if your life insurance is your trust, then it'll go into the trust and go through that process. But yeah, any direct beneficiaries, they'll just communicate, the beneficiary will communicate directly with the institution, fill out the right forms, and turn it over into their account. And those skip any expenses of administration, right? Because they go straight to the beneficiaries. So whatever the cost of administering the trust is, and the last tax return and funeral expenses and all that stuff, those would just come out of the trust. Okay? So now when they get to the point where they say, okay, all the bills have been paid, the last tax return is due, or is done, we've liquidated the real estate, we've got the life insurance, we've collected everything, right? We put together a proposal for distribution with either an accounting or very strict waivers of their rights to an accounting. Okay, so they can waive their right to an accounting of the trust. So the proposal for distribution will outline, much like this trust report did, what the ending assets are, okay, their value, and how the trustee proposes to distribute that to each beneficiary. Okay, if by that point, sometimes by that point, we've consolidated all the accounts, we've liquidated everything, and we've literally got one checking account in the name of the trust with cash. It's really nice and easy to propose how we're going to distribute that. But it's not always like that. Sometimes there's a house and a car and another house and some stocks and some other things, and people want different parts of it, right? So we've got to make sure all the beneficiaries agree to those types of offsets, right? That it's got to be equalized in whatever way your trust requires. The accounting is required unless every beneficiary waives. Okay? And by every beneficiary, my opinion is that even includes the ones that you've said that have specific gifts before your final distribution. You know, if you've said I want $10,000 to go to this charity and $10,000 to go to this one grandchild, and you know my car to go over there, and then the rest goes this way. Those sort of specific gifts, even I say, need to waive for the accounting. If they don't all waive, then that's where you look back at this trustee report that was done way at the beginning, and you pull together all the records between there and there, and you do a reconciliation. You have a beginning list, which is that. You have an ending list, which is what you have at the end there. And you've got to show transactions in, transactions out, increases in value, losses of value, which should reconcile to your ending statements. Okay? And then that gets disclosed to the beneficiaries in a certain amount of time to object. If they don't, then it's deemed accepted. Okay? And that protects your trustee from ever being sued by a beneficiary. If you don't do either one of those, and your trustee just makes the distributions, the beneficiaries have up to 6 years to sue the trustee after this point. Maybe even longer. Yeah?
At that point, when you're making distributions, let's say to individuals, when I did this for my parents, I wrote a real simple couple of sentences saying, when you accept this check, you waive all further rights. Yeah. End of story, correct?
It's not that clear. It's better than nothing. It definitely is better than nothing. Okay?
The other thing I did on the same thing was, I'm withholding so much for another year.
Yeah.
And it's surprising how many phone calls and letters I got from phony collectors or this or that and so on.
Yeah.
Thankfully, I didn't have to use any of it to fight the flies off.
Yep.
And I was able to disperse it later.
Good.
And everybody was happy with that.
Good. Yeah, we will typically, in that proposal for distribution of the main trust assets, we will say in there, we're holding back 5,000, 10,000, 20,000, whatever we need to on each case as a reserve, just in case. And we recommend that all the time.
How often do you have beneficiaries come back and cause trouble, and what kind of situations? I mean, you know, drug addict children, or
Say that.
I mean, what sort of circumstances are the kind of beneficiaries that come back with problems?
We get phone calls every day, not on our clients, but on, you know, somebody died 5 years ago and Aunt Maddie didn't do it right and she never blah, 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 blah. Can we sue her? And the answer is, yeah, probably. I mean, it's not that hard to distribute assets out of a trust. And so folks will do it. And maybe 9 times out of 10 it's fine. We just get all the bad calls, right?
And are these people that there was a trust, or people, I mean, like when my mother passed away, there was no trust, we just,
You
my
just
brother,
split it
I
up.
just took care of it.
Yeah, some do, some don't. I mean, one right now where the kids are hiring us because the dad died about 5 years ago, and the dad set up trusts for the kids, put mom in charge of the trust. I think they were separated, I don't think they were divorced. And mom did distribute some money, but never did anything formal. Never showed them the trust, never told them how much there was. And it's literally like 5.5 years since dad died, and we're starting a case against mom. I don't know if she had ill intent or not, but she didn't do anything, she didn't do the formal stuff. And so they just don't have all the information to know what actually happened. So there was a trust, and we'll find out. I mean, but these are just the things that are available.
Bottom line is, the trustees should have you hold their hand.
I mean, we always say, have your trustee call us, have your trustee call us. That first conversation doesn't cost you anything. Have your trustee call us. I mean, there's never, it's never a bad time to call when you're in these phases of life, because there's liability. There's just a lot of liability. And the last thing I want is for one of my trustees to be stuck holding the bag, because most of our trustees have the best intentions, and we want them to be out of pocket on this stuff. So if you don't, like I said, if you don't get one of those, if you don't do the full accounting or you don't get the waivers, then that liability basically is residual for at least 6 years. And that's a long time for something to hang over your head. I mean, most trustees, they want to do the job, they want to do it well, they want to be done. Okay. So,
If there is like some stock in the assets,
mhm.
and that do you ever advise that they go ahead and distribute that equally if that's, the situation? In case the stock would really go down, then is the trustee kind of liable?
Yeah. So after death, and part of the asset mix is some stock holdings.
Mm-hmm.
When that's the case, because if it's not in an IRA, if it's just a stock portfolio brokerage account, all of those stocks get a new stepped up basis and value. You gotta make sure everybody remembers that at the time of death. So literally, if you bought stock 100 years ago for $1, and when you die, each share is worth $1,000, but you haven't, if you sold it the day before death, you pay capital gains tax on the $999, okay? If your trustee sells it the day after death, they pay 0 capital gains taxes, okay? So in those cases with the trustee taking over, we want to liquidate it immediately, as soon as possible. I mean, as soon as possible. If down the road a beneficiary wants to reacquire that stock, they can reacquire the stock.
Yeah,
You just don't have the stock people.
Journal it over into their
Yeah,
accounts.
put it into the 3 accounts.
No, because there's going to be at least 6 months before we do that. To get through administering the
You
trust.
can't distribute it that way rather than liquidate.
You can, but you've got 6 months of market volatility
Oh,
that the trustee is going to have to live with. I mean, I have one right now where the gal had a $2 million stock portfolio, and they didn't liquidate it because all the beneficiaries said, we don't want you to. We want the shares of these of the stock.
uh-huh.
And it's been about 1.5 years since she died. The portfolio's gone, or the whole thing has gone down about 40% in value. Now everybody's looking at the trustee like, you screwed me out of blah, blah, blah. She was trying to do what they all wanted. you know? So there's just not any good reason
So liquidate.
to hold on to it. After death, you take advantage of the step up in basis, pay no capital gains tax. If it's a really weird privately held stock, we have some clients that own privately held shares of small banks that aren't on the public market, so you can't reacquire those. Okay, we get it, right? But that's not what we're talking about. Anything on the stock market, sell it. Beneficiaries want to buy it later, they can buy it later. Like, they'll buy it at their own price and we won't have lost anything, you know?
Excuse me,
Yeah.
you're saying sell it, but you also said stepped up basis. So why wouldn't you want to give or bequeath the value of the stock as a stepped up basis if they want to hold on to it?
Because I'm talking about from the trustee's perspective. Okay, so the moment of death, trustee is now responsible for all the assets. One of the first things is to protect the assets. Okay, so you guys can invest your money however you want. You can be 100% all in Apple. You can be 100% in penny stocks. You can be as risky or as risk averse as you want. Trustees aren't allowed to be that way. They're not. They have to follow what's called the prudent investor rule.
Well, excuse me,
Yep.
in this case, let's say I'm the trustee and I've expressed to the
To the
following
successor.
Successor trustee
Uh-huh.
that we want to pass on this in a stepped-up basis. So that would be a reason that trustee could do this.
Yes, the trustee can. Yes.
And so we could be saving several $100,000 worth of taxes.
You're going to save that regardless. You're going to save that regardless. What all I'm talking about is if your trustee decides to hold that stock until administration is done and the stock value drops, and then the trustee distributes the stock, the beneficiaries might have a claim against the trustee for the lost value. Okay? Yeah.
Is there any way to protect the trustee, like a mark-to-market letter, disclaim to the beneficiaries?
You can, yes. And you would again want waivers from all the beneficiaries that we approve the risk of loss, blah, 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 blah. Yep.
What about the possibility, say, suppose you have, well, chunkier assets in stock, but probably not too much that you need to worry about keeping it for the 6 months or whatever you're dragging it out. What about selling the stock and distribute that to the beneficiaries right away?
Yeah. The whole thing, the whole mix of assets of the whole trust has to be taken into consideration, right? So if you've got $1 million in assets and you got $10,000 in stocks, okay, whatever, we're not going to worry about it. But if it's $900,000 in stocks, number one, is it, are we diversified enough here that if some go down, the others are going to go up, kind of thing, and we can make that assessment, right? But the trustee it's not like it is while you're alive managing your own portfolio, where if it goes down, you kind of go, man, they could be held liable. Okay, that's what I need to get across. And so, yeah, if there's not a specific intent of this is stock that I inherited from my dad and inherited from his dad or whatever, it's just emotionally we're vested in this company and we want this to pass down the family line. If that doesn't exist and it's a publicly traded stock, there's much less risk to the trustee to just sell it, distribute the cash, let the beneficiaries rebuy it in their own brokerage account. Okay.
What about real estate?
Same thing with real estate. Real estate has less volatility, so there's not the immediate need typically, and real estate does take longer to clear up and sell, so those are the kind of things that do need to happen relatively quickly. One of the things in protecting the assets is the home. We always tell the trustee, get to the house, make sure it's secure, landscaping is being watered, not, everybody doesn't have a key to the house, that, you've got the keys to the house. If they need an alarm, make sure it's got an alarm, and start to inventory the contents. It shouldn't be just a free-for-all, where everybody can come into the house and take whatever they want. It should be a little bit of a formal process, at least with the trustees supervising it, and all of the beneficiaries present to, make the agreements on who gets what. And then the rest donated or liquidated.
Maybe this time, I've been wondering about this question as you've been going along, illustrating a number of these pitfalls or challenges for the successor trustee. What about having the person that you have appointed or thinking about as a successor trustee, a co-trustee?
As a co-trustee?
Yeah. For example, in my case, my wife and I, all these things about whether I have a stroke or, my wife has Alzheimer's and all the timing kinds of things.
Yeah.
A lot of things you've talked about seem to be time is of the essence issues. And on the other thing I'm thinking about, maybe you can talk to this, bring in the idea of tax. For example, if my wife and I are both in an accident, we both become incapacitated but still alive. I mean, we can't make our own decisions. It's like a big wall seems to be coming down. Whereas if instead of having a successor trustee, we have a third person, co-trustee. Would Dean and Mary have something to do, mess things up, and also would it be easier for taxes? Like, for example, if we die or something, our brokerage account needs to be notified that the trust is changing, and it seems to kick in a lot of problems. So it weighs a lot of red flags. Your tax ID number can change on you. They lock you down. It's pretty awkward.
Yeah. With a co-trustee, so a couple things about co-trustees. It can work well, and it does work naturally when it's a married couple acting as co-trustees over their joint trust. When a non-spouse is brought in as a co-trustee, that person takes on every single liability and responsibility I just described in the last hour. So it's complete liability, not just for what they do as co-trustee. As co-trustee, they're 100% liable. And I see your eyebrows, furrowed, like, what? They're 100% liable.
So that co-trustee would also own the house, for example.
Yes. Needs to be on the house as a co-trustee, on all the bank accounts, on the investments, on the insurance, on everything. And it's the same process I described to go through with a starting date and an inventory and all of that, because me as a co-trustee stepping in to take care of somebody else's business, even if they're still well, I don't mind helping, but I also don't want to get in trouble. I don't want to get in trouble. And as co-trustee, that one of the biggest risks is that we see this is I'll just put my name on as co-trustee. That way, when you start to need more help, I'm already here. And I won't really mess in any of your affairs until then. Well, great, but guess how it usually happens? After the fact, we find out, oh my gosh, they just got swindled for, blah, 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 and I've been co-trustee this whole time, not really looking over and watching things, right? Because I didn't want to step into their life. I didn't want to mess with their life. That's why it's you're either all in or you're all out. Okay? So it can work if the agreement is you're all in. Now, adding a third one, like in a married situation, adding a co-trustee in that, I've never done before, I've never seen it done before. My guess is it would just add some administrative complexities to your day-to-day life, because that third signature is gonna be required in a lot of different places on your normal business. And you may or may not want that, and then the successor, or the third co-trustee is gonna have to be part of all the decisions. You know, the investment decisions, the spending, you know, and that may not be something you would want in your day-to-day life. Shaking your head no.
What happens with, okay, so husband and wife co-trustees, and now one of them gets Alzheimer's or whatever, but insists they're okay. How does the other co-trustees finally get control of this thing?
Very delicately at first, and then by drawing a line in the sand at some point. It's not easy. Those are the hardest times probably in my whole career, is when we have to inch our way into somebody's financial life, and it's just hard. It's just really hard. One of the things is we will send the client for a neuropsychological evaluation, which is different than a neurologist. Neurologist will just look at the medical aspects. They'll do the Oriented ×3 and blah, blah, blah. They'll run some tests and they'll produce some scores. A neuropsychological or psychiatric exam actually has the specific result of telling someone you have the capacity to manage your financial affairs, or to manage your personal day-to-day habits, or you don't. And even on a spectrum, you have the capacity to decide if you want chocolate or vanilla ice cream and what you want to wear today, but not to drive and not to pay your bills. You know, there's a very unique spectrum that they can produce out of that report. And a few times we've had to do that, and it has come back in the negative. That has been enough to transition authority. That's been enough for the client to go, oh wow, I didn't realize it was that bad. Okay. And if they won't, there is there's a couple other procedures that we could use, right? But yeah, it's tough. It's tough. Did I answer your questions there?
Yes,
Okay, good. I think we're nearly at our end. Let me just flip through this and see if I covered things that I want to make sure I covered. Oh, this is important. The person you designate as trustee, they are prohibited from self-dealing. So you name your successor trustee. Obviously, while we're incapacitated, they're not taking any benefits from the trust except for reimbursements or their own compensation for their services. After death, your trustee might also be one of your beneficiaries. All right, that happens a lot. Well, what if the trustee says, look, as part of my share, I'd really like the house. Or as part of my share, I'd really like the car. Or I'd really like that stock account, or whatever. Can they just allocate it to their share? We only do that if all the beneficiaries agree, okay? They do get final say, and they can make those types of decisions with respect to the other beneficiaries. So if another beneficiary says, I want the house, I want the car, I want the stock account, the trustee can make that part of the allocation without everybody's agreement. But they can't do that in their favor. Okay? The other thing that happens is the trustee will maybe want the car or want the house, and we can accomplish that by simply having the trustee purchase it from the trust. So as an individual, they buy it from the trust. The trust then gets a pile of money, and the trustee gets a house. And then that purchase transaction is basically put out for bids. And if any higher bid comes in, well, great, we get more money. But if not, then they can purchase it. So they can't self-deal, what those things are called.
But that could be in a will. For example, my widowed aunt moved back in with my grandmother and took care of her for years and was living in the house and so on. That was, I mean, they didn't have a trust, but in that case, the will could just say the house goes to.
Sure, yeah, if the will says, if the will says the house goes to you, then it goes to you. Yep. Okay, I think that's all I had on my little list here. Any questions about that?
Safety box.
Safety box.
Anything we should know about that?
Yeah, safe deposit box. You want to make sure your successor trustee is added to that. Or that it's at least in the name of your trust. Okay. If it's in the name of your trust, then it will be part of the assets they can mark with. If something's not in your trust and you become incapacitated or you pass away, your trustee's going to have a much harder time and may not even ever be able to get to it without a court order. So that's why we are always harping on our clients, make it owned by your trust, make it owned by your trust, make it owned by your trust.
So if you have a safety deposit box at a certain bank, and your bank account is in the trust, that doesn't necessarily include the box?
Not automatically, yeah. It usually does, but not automatically.
Okay.
So yeah, check on that.
So I don't think our cars are in the trust. Is that something we should do?
Cars are, there's a few different ways you can deal with cars. You can either make them owned by the trust, or ADOT has a beneficiary form
Oh, yeah, I think I remember that. Okay.
that you can simply fill out, notarize, say the trust is the beneficiary, you staple it to the title and just hold on to it. And then if at some point you die and have that car, that transfers it straight to your trust.
Should we give the trustee all the information about access to your brokerage account and your checking account in advance, or do you wait until you start the 12, what you got for that 12/14 date?
That's a personal decision. The more prepared you can make your trustee before the date, the better they're gonna be at their job.
I guess, yeah.
Some clients are just free-flowing, open, transparent. They don't care if everybody knows, if it's on the internet. They just don't care. Some clients are very private. And so you gotta just decide. I'll just give you that rule of guidance that the more information, the more prepared you can make your trustee before the day comes,
The easier it
the
becomes.
much easier it becomes.
Gotcha.
Yep, so if you're the kind of person that's comfortable sharing it with them, I know that it makes it easier. But if you're not, it's the kind of thing why I say have the records organized somewhere. That way they can go and pull it, right? Okay.
In step 2 there, any income that would be coming in, normally your pension and all that,
Yes.
would go into, because you've notified them that you're the trustee, it would come to that trustee account?
Yes, it will.
What about things that you didn't know was coming? How do they deal with that?
Well, it'll depend on what it is. Do you have a specific example or just kind of in general?
Well, I guess I think in general.
Okay, so in general, what'll happen is the Social Security pension, they'll continue to be deposited in the same account they always were, which should be a trust account, okay?
Uh-huh.
Then your trustee can go and put their name on that account as trustee. Any other checks that come in, they can usually just be deposited straight into that account without any trouble, okay? I don't think I've run into any problems. If there were a problem, if the bank wouldn't deposit it, then what we would do is we would request the issuer to reissue the check in the name of the trust or to the person as power of attorney, and then they would deposit it. So, yeah, we have,
And dividends from stock would be the same way that maybe I or the person had wanted them to be in the first place, like reinvested or
yep.
come as a check, one or the other.
Yes, and they will, if they come as a check, the check should still be made to the trust because the stock should be owned by your trust. So the dividend check should come to your trust as well.
Okay.
Yep. Good. Any other questions? No? You guys are easy. Not like the lawyers I teach, they come up with crazy hypotheticals that will never happen.